In this video, we go deep on the directive principles that are most heavily tested, most controversial, and most important for both prelims and mains. We will cover Article 44 on the Uniform Civil Code, Article 39B and C on material resources, Article 40 on panchayats, Article 45 on early childhood care, Article 47, Article 48A, and Article 51. Let us start with Article 44, the most controversial of all directive principles. Article 44 says the state shall endeavor to secure for citizens a uniform civil code throughout India. This means one single law governing marriage, divorce, inheritance, and adoption for all citizens of India regardless of their religion. Right now, different religious communities in India are governed by different personal laws. Hindus, Sikhs, Jains, and Buddhists follow the Hindu Marriage Act of 1955 and related laws. Muslims are governed by Muslim personal law based on the Shariat. Christians have the Indian Christian Marriage Act of 1872. Parsis have the Parsi Marriage and Divorce Act of 1936. Why did the framers want a uniform civil code? Primarily two reasons. First, gender justice. Personal laws of several communities discriminate against women in marriage, divorce, and inheritance. A uniform code would eliminate this disparity. Second, national unity. Having different laws for citizens based on religion creates a sense of separate identities. A common civil code would create a unified civic identity. The Supreme Court has asked Parliament to enact a UCC at least 3 times. In the Shah Banu case of 1985, the court upheld a Muslim woman's right to maintenance under secular criminal procedure law and called for a UCC. The government responded not by passing a UCC, but by passing the Muslim Women Protection of Rights on Divorce Act of 1986, which legislatively overrode the Shah Banu judgment. In the Sarla Mudgal case of 1995, the court again called for a UCC. In the John Valamadam case of 2003, the court called it a matter of regret that the directive had not been implemented in over 50 years. Then in 2024, Uttarakhand became the first state to enact a uniform civil code. The Uttarakhand Uniform Civil Code Act of 2024 covers marriage, divorce, inheritance, adoption, and even live-in relationships. Scheduled tribes are exempted. This is a landmark development. No national UCC exists yet. Now Article 39B and C. These two subclauses of Article 39 are constitutionally special because they are the only two directive principles protected by Article 31C from fundamental rights challenge. A law that genuinely implements Article 39B and C cannot be struck down on the grounds that it violates Articles 14 or 19. Article 39B says the ownership and control of material resources of the community should be distributed to best serve the common good. Article 39C says the operation of the economic system should not result in concentration of wealth to the common detriment. For decades, governments used these provisions to justify nationalization of banks, coal mines, and other industries. The question was whether private resources could be treated as community resources under 39B. In November 2024, a 9-judge bench of the Supreme Court decided the Property Owners Association versus State of Maharashtra case. By 8-1, the court held that not every privately owned resource automatically qualifies as material resources of the community. The state cannot simply take over private property by claiming it is a community resource. The state must demonstrate that the particular resource genuinely subserves the common good. This significantly narrowed the scope of state power under Article 39, compared to earlier readings. Article 40 is the panchayat's directive principle. Its importance is not what it says, but what it became. For 42 years, it was a non-justiciable aspiration. Then the 73rd Amendment of 1992 made Panchayati Raj a constitutional requirement, converting this Gandhian directive into enforceable constitutional law. Article 45, after the 86th Amendment of 2002, covers only early childhood care for children below 6 years. Education from 6 to 14 years moved to Article 21A as a fundamental right. This change is frequently tested. Article 47 has 2 mandates in one article. The first part is socialistic. The state shall regard raising the level of nutrition and the standard of living of people and improvement of public health as among its primary duties. The right to health under Article 21 is read with this provision. The second part is Gandhian. The state shall endeavor to bring about prohibition of the consumption of intoxicating drinks and drugs injurious to health. Both mandates in one article, straddling two categories. Article 48A was added by the 42nd Amendment of 1976. It says the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. This article must always be paired with Article 51A Clause G, the fundamental duty added by the same 42nd Amendment, which requires citizens to protect and improve the natural environment. Together, they create a constitutional environmental protection framework. One is a state obligation. One is a citizen duty, both added by the same amendment. Article 51 on international peace has 4 parts. Promote international peace and security. Maintain just and honorable relations between nations. Foster respect for international law and treaty obligations. Encourage settlement of international disputes by arbitration. India's Panchsheel principles and non-alignment policy both draw from Article 51. Now your MCQ. Which of the following about Article 39(b) is correct following the Supreme Court's judgment in the Property Owners Association case of November 2024? Option 1. All private property in India automatically constitutes material resources of the community and can be redistributed by the state. Option 2. Private property can never qualify as material resources of the community under any circumstances. Option 3. Private property can qualify as material resources of the community, but the state must demonstrate that its redistribution genuinely serves the common good and cannot take over private resources arbitrarily. Option 4. The Supreme Court held that Article 39(b) is not a justiciable provision and cannot guide any state action. Think carefully. The correct answer is Option 3. The 9-judge bench held 8-1 that private property is not automatically a community resource, but it also rejected the view that private property can never qualify. The nuanced position is that private resources can be included within Article 39(b), but the state must show genuine subservience to the common good, not arbitrary appropriation. Option 1 is the overbroad interpretation the court rejected. Option 2 goes too far in the other direction. Option 4 is wrong because directive principles are used as interpretive guides by courts even if not directly enforceable.